housekeeping matters before we bring the jury back in. I guess the big question is, do you want to go ahead and release them so that they can, when we're done, have them go for lunch and then come back and do closings and everything after lunch?
Judge, I would prefer to release them and then do closings after lunch.
And what I was going to ask Judge is, because I believe Dr. Downs is the state's last witness, that my cause is going to be limited brief, that I assume that what I would ask is the state rest at that point, and I'll rest at that point thereafter. Do a motion for a directed verdict outside the presence of the jury. So sort of do it in reverse order, that I rest first, send the jury to lunch, we have our motion for directed verdict hearing, and then whatever other charge conference we need to clean that up, come back, and then we can do closings. So I guess what I'm saying is, I'll rest on the record after the state rests, but reserve the motion for directed verdict so that we don't have to bring them in and back out. That's all.
Any objections from the state?
Absolutely not, Judge, thank you.
And I've used up all my words that I said. What do I got, doctor? You're a doctor. What do I have? Sinusitis? What do I have? The diagnosis of it.
You don't want him as a doctor.
No, because it's too late.
Well, my procedures are a little invasive.
I see, yes.
Are we ready for the jury?
Yes, Judge.
Yes, so we got work.
I think that's great. Please be seated. All right, Mr. Greenwald, cross-examination.
Thank you, Judge. Good morning, Dr. Downs.
Good morning.
Hopefully you can hear me and understand me with my raspy voice. Do you want any water or anything?
I'm fine, thank you, sir, I appreciate it.
No problem. I just have some clarification questions for you, Dr. Downs. You did the autopsy on November the 24th, 2021.
That's correct.
Okay. And Amari, as far as we believe, her body was located, discovered the day before, right? November the 23rd, 2021?
Yes, sir, I did the autopsy about 11:30, and she was pronounced dead about 12, probably found maybe an hour before that, the day before.
Okay, so the day prior. Based upon your examination of her, can you put an approximate time frame on her death in relation to the 23rd of November of 21?
I would really be hesitant to do that for a lot of reasons. One is that she's in plastic bags, so that hinders decomposition. It's November, so the temperature's going to be important, hot, cold. She's in a wooded environment, so the sunlight coming and going, it would really take a lot more detail for me to be able to say when she died. In addition, I don't know if, because there's an interval, what the conditions were between when she died and when she was placed in this environment. That's not something I feel comfortable telling you a definitive answer to.
Okay, could it stretch from a couple of days to a week out, or you're hesitant to even go that far?
It would depend. If she didn't have any refrigeration, for instance, if she's in a cold refrigerated room, that would slow down decomposition. I would really need to know more about the weather, the environment. I can tell you this, if all else being equal, she didn't appear to have a lot of decompositional changes. Instead, what she had was animal depredation.
Because this was late November and the weather tends to be cooler?
Yes, sir.
Late November, okay. Well, let me ask it this way. In regards to the laceration of the liver, would that in and of itself have caused her death?
Not Amari's death, but if you took somebody in every other way, shape, and form like Amari and inflicted that liver injury to them, that person could die just from that liver injury, but that's not Amari. Amari had everything else going in that physiology we talked about with battered child syndrome.
So the lacerated liver, if untreated, that would not in and of itself have caused her death if the injury was left untreated for a period of time?
Again, you can't isolate in Amari's case one thing because it didn't happen that way. You have somebody who has this background who then has an injury inflicted on her. If you take somebody else who's not Amari, but just give them that liver injury, then that person could die with an untreated liver injury like that.
What would be the time frame for a person to die from a lacerated liver?
Again, exactly the circumstances, like Amari, it's hard to say. If it's not her, but somebody with just that liver injury, I'm not a clinician, that is, I don't treat people. I can tell you that I would think a couple of hours would be probably pushing it. She had 120 milliliters, which is 4 ounces of blood in her belly. Her total blood volume for a kid of her weight, now she probably has less because of her malnutrition, but they would have 1.8 liters. So think of a 2-liter bottle of Coke. She's almost that much blood, 1.8, so almost a 2-liter bottle. And she's lost, you got a 500 milliliter, and she's got 120. So she's lost a significant volume of blood, 7% of her total blood volume, something like that. That's what I could measure. But there's more blood I can't measure. Like that 3.5-inch clot over her liver, I can't measure that. The blood in her lung, I can't measure that. The blood in her heart, I can't measure that. The blood under her skin, I can't measure that. She lost a significant blood volume.
Would she have lost consciousness over a period of time?
At some point, I would expect her to lose consciousness just from the loss of blood.
Can you estimate a time frame from the loss of blood?
I can't do that. It's different for different people, and also with her malnutrition, her hematocrit, the percent of her blood that's red blood cells, which tells us how much oxygen she has the ability to carry. I can't assess that because I don't know. She may have started with a normal of 40%, say, and hers may have started at 30% because she's malnourished.
In your autopsy, I think you noted that she had a right rib fracture. Would that have occurred prior to her death, after her death? Do you know one way or the other?
Yes, sir. Both of the rib fractures, both the right and the left, were older. That's part of the basis of the battered child syndrome.
So it was both right and left?
That's correct. The left was fresher, but still old.
Can you put a time frame?
It's really, really hard to do. I would say with the fracture callus, which is when you get a fracture, the two ends of the bone come together and you get a lump where those two bones come together. On the left, that lump, you could see where the fracture line was. So that's probably weeks. And then the other side, I didn't see that pattern, so that's probably months, or it could be much older.
Understood. The blood work that was done, that all came back negative for drugs, if I understood, on page 20 of your report.
That's correct. So we send our samples out to the GBI lab, and in this case, we also sent out for chemistry to a different lab. But the blood work for drugs was all negative, and the other lab didn't find any drugs either.
Okay. And needless to say, this was not a case where you found any type of gunshot wounds, stab wounds, anything of that nature, correct?
No, sir. Exclusive of what we talked about, the multiple blunt force injuries and the older healed and healing injuries, the battered child syndrome and the malnutrition. This was an otherwise healthy young girl that had no additional trauma.
And we've used a couple of terms here when the state was asking you some questions. Scabs. What specifically are we talking about when we're talking about a scab versus a scar?
So a scar is actually fibrous tissue that mends together, it meshes together. So it's almost like weaving it back together with tissue that binds the edges of the wound together, and the skin becomes intact. A scab is a layer of dead cells, pus, dried debris that forms over the surface of a wound. That's during the process of healing. So while that scab is there, you're getting healing underneath the skin, but the skin is not fully woven back together. So that's the difference, is the scar means this is old. The scab means we're still working on it. It's still in the process of healing.
And I realize every person, every human being is different from the next one, but generally speaking, how long does it take for a scab to occur?
It can happen very quickly. When the wound is small and exposed to air, the blood's going to clot on the surface and can heal. I mean, I would say common experience would be the best way to answer that. You've seen those, but the thing is, you also have deeper wounds that heal more slowly because they are deeper and it takes more time. There are some wounds that don't get stitched back together. You stitch an open wound to bring the edges together to allow that fibrosis to happen underneath. The scab forms on top. Those heal very quickly, so those scabs don't last a long time. versus an open wound, it takes longer. And I just can't give you a precise timeline.
Would it potentially be within a couple of days?
Depending on the type of wound. A deeper wound is not going to be a couple of days. It's going to be longer.
Okay, and again, knowing every person is different, how about in regards to a scar? Is there a particular time frame for a scar?
Where I can tell you that it will be scarred, I don't think you can really do that. If you've got scabs, kids pick at scabs. That then kind of sets the clock back a little bit. Also, with her malnutrition, she's going to heal more slowly. So I really can't give you, I wish I could tell you, it's going to take 2 weeks, it's going to take 4 weeks. That wouldn't be accurate.
The malnutrition affects someone's skin,
It affects the entire body.
but specifically in regards to the skin, what's the effect of malnutrition on a person's skin?
Well, you're going to lose subcutaneous fat, which means the skin is going to be thinner, and you lose the immune response becomes impaired, so the white blood cells that come in to help with repair are going to not work as well.
Would it be more susceptible to bruising?
I would say probably it would be more susceptible to bruising because you wouldn't have the structural integrity, you wouldn't have the subcutaneous fat. So yeah, I would say probably more susceptible to bruising. And also depending on what's missing, for instance, vitamin C, scurvy, that condition, and others like vitamin K, clotting factors. Yeah, I would say probably more prone to bruising.
Okay. You also had mentioned in the direct, use the word fresh in regards to fresh injury or in the context of wounds and so forth. Can you elaborate a little bit when you use the word fresh in that context, what you're referring to?
Not to be smart in the answer, but it means not old. So I'll try to explain that a little better. Fresh would be anywhere from it just happened out to where the white blood cells, specifically a type of cell called a PMN, a neutrophil, that's the same cell. Those come in by a couple of hours. I expect to see those specific cells. Out to 2 to 3 days, I see different types of inflammatory cells, and I see red blood cells breaking down. So when I say fresh, it's somewhere from that just happened out to where I get the white blood cells, the neutrophils, and some other reactive changes, but I'm not seeing that second wave of inflammation coming in. So we're not talking 2 days.
2 days from the time, obviously, you're examining.
No, sir. The clock stops when you die. So what I'm saying is, whenever these events, when these fresh injuries happened, was within that time frame of when she actually passed. So the clock stops when she passes.
So within 2 to 3 days of her death, of her passing.
Correct.
And when you mentioned in your report, Dr. Downs, the manner of death being homicide, that doesn't equate to murder, that just equates to death at the hands of another?
That's correct. Murder is a legal term. We specifically don't use that word. I am not an attorney, don't pretend to be one, don't know much about the law at all. I know enough to ask a lawyer.
Okay. So that in and of itself just means death, when you put homicide, death at the hands of another.
Right. Literally, the word itself is homis, H-O-M-I-S, side, to kill. Homis is human or man. One man or one person kills another person. That's all it means.
And obviously, when you got involved in the case, you can't make a determination, speculate, do anything of that nature in regards of who or whom may have inflicted those injuries that you noted, correct?
No, sir, I don't speculate, and I do not identify perpetrators. That's not my job. My job is to tell you, this is what I saw. This is what happened to Amari. These are all the conditions that are there, and it's up to investigators to take it from there.
Thank you, sir.
Thank you.
No regret, Your Honor.
May the witness be excused.
Yes, Your Honor.
No objection.
All right, thank you, Dr. Downs, you're excused.
Thank you, Judge.
Thank you. All right, any other evidence from the state?
Your Honor, at this time, the state would rest.
The state has rested. Mr. Greenwald, any evidence from the defense?
Your Honor, at this time, the defense would rest on the presumption of innocence in our favor, Your Honor.
Thank you, sir. All right, ladies and gentlemen of the jury, it's, wow, it's early. It's 11:10. So we're going to break early for lunch today and come back at 12:30. Be sufficient?
It would, Judge.
Want you guys to be back in jury assembly at 12:30. Remember, no talking, no watching, no reading, no listening about this case. All right, Mr. Greenwald.
Judge, with the jury out of the courtroom on behalf of my client, I would at this time make a motion for the record of acquittal in regards to counts 1 through 18 of the indictment. She's not charged in count 20 in good faith. Judge, I don't believe I can make a verdict in regards to counts 19 and 21. However, in regards to counts 1 through 18, I would ask the court to direct a verdict of acquittal, in that our position is that the weight and sufficiency of the evidence introduced by the state up to this point are not sufficient as a matter of law for the jury to return a verdict of guilty. Specifically in regards to the murder, the malice murder, the felon murder charges, Judge, there has been no direct or even circumstantial evidence I would submit to the court that showed, at least to this point, that Ms. Owens aided, abetted, assisted Ms. Hall in the death of Amari. Further, I would submit to the court there's no direct and even circumstantial evidence that Ms. Owens directly caused the death of Amari. And so for those reasons, Judge, we would respectfully ask the court to direct a verdict of acquittal.
Thank you, sir. Ms. Nazan.
Your Honor, the state would strongly disagree with that, given the nature of the evidence that's come out during this trial, and not only the videos. I think the videos would be more than sufficient to allow the jury to make a decision as to whether or not this defendant was involved directly or indirectly with the cruelty to children charges. As far as the murder charges are concerned, Judge, there is, in the state's opinion, enough evidence, sufficient evidence for the jury to consider all the injuries that were inflicted upon the victim in this case, and take that under the guise of a party to a crime as a participation of this defendant in inflicting those injuries, which ultimately led to the death of the victim. And therefore, the state asks that that you deny defense counsel's motion and allow the jury to have this case to make their ultimate determination.
All right, thank you, ma'am. All right, Mr. Greenwald, taking into consideration the evidence that's been presented throughout the trial, the court is going to deny your motion for a directed verdict. There is sufficient evidence for charges 1 through 18 to go to the jury.
Yes, sir.
Thank you.
I'll just accept for the record.
Your exception is noted. All right, I have prepared new copies. Tracy's that said about McKinley trees, of the proposed request for charges.
Thank you, Rob.
So, one for you and one for the state.
Thank you.
All right, so can we start first on page 5 with witness impeached?
We're holding that against the defendant testified, since she chose not to testify, but we don't need that charge.
That was way too fast.
We left that charge in the event the defendant chose to testify and she was impeached on cross. That didn't happen. I don't remember there being any other impeachment of any other witnesses in trial, so I would say that charge is not.
I would agree, Judge.
All right, 1.3, 1.45, witness impeached is withdrawn. So also on page 5, 1.32.10, defendant's choice not to testify.
just the second paragraph, I think we're fine.
Agreed. Going to page 7, 1.32.50, conditions precedent to consideration of a statement. The last sentence with the parentheses.
Given that we removed the previous impeachment charge, I was hoping to remove this language as well.
I think all of it, does, I mean, because it says credibility of the witness, so she never testified, so I don't think that.
So, correct, so the entire parenthetical and impeachment should be removed, correct?
Yes, ma'am.
Can we go back for a second, going back to page 5, 1.32.16, statement of the defendant? We had previously left that in.
I believe at this juncture, to avoid having to define which part of the statement was in custody and which part was not, we should put all the parentheticals in and then run for caution. Right.
Yeah, I didn't have a strong preference one way or the other.
Any objection to that, Mr. Greenwald?
No,
All right, we'll leave that in. Voluntariness defined, burden of proof as to voluntariness, and constitutional rights.
yes, sir.
And I think the only other thing remaining, page 12. Two point 20.21 aggravated assault. The state requested that we modify the language so that it tracks that of the statute as opposed to the pattern. And it says for an aggravated assault, defendant, 1, assaulted another person, 2, with an object, device, or instrument when used offensively against a person, should be a person, is likely to or actually does result in serious bodily injury. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person. An object, device, or instrument when used offensively against a person that is likely to or actually does result in serious bodily injury is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone.
Your Honor, the state is good with the language that was modified there in 2.20.21, and because of those modifications and the fact that the last paragraph there defines what the object used offensively means, I think we don't need 2.20.23.1. The section right below that. Because that talks about deciding whether an object is an offensive weapon. We took out the language of offensive weapon, and the last paragraph above that defines how an object is used offensively, so I'm going to do the same.
So you're withdrawing S 34.
Yes, sir. We say we withdraw that 34, given the change in language to the assault.
I think we should give it, especially if you want to include, although the hands and feet are not deadly weapons per se, they may or may not be deadly weapons depending upon the manner in which they are used and the circumstances of the case. Whether hands or feet constitute weapons in this case are factors solely for your determination. This defines what an offensive weapon is, an object, device, or instrument, the nature and extent of the injury inflicted, the manner in which an object, device, or instrument was used, and any other circumstance. I think all three go together.
Okay, I don't think it's going to hurt anything to leave it in, it's leaving it there, so we can leave this on.
Mr. Greenwald?
Yeah, I have no problem with it.
And so then we have the state's request to charge on hands and feet as weapons. It's a non-pattern, and it's from the case of Green versus the state, 291 Georgia, 287, the 2012 case. And then Sandstrom, Sandstrom versus Montana, 442 U.S. 510, 1979 case. Any objection to that instruction, Mr. Greenwald?
The only request I would have, Judge, is page 12, where it says whether hands and feet constitute weapons in this case, I would ask that where it says whether hands and feet, comma, if used, comma, constitute weapons in this case, or factors solely for your determination. Otherwise, it sounds like court is quasi-commenting on the evidence in the case. And I think that's the province of the jury to determine first if hands and feet were used. Does that make sense?
I understand what you're saying, yes, sir. What says the state?
That's fine with us, Judge.
So whether hands and feet, if used, comma, if used, constitute weapons in this case.
Yes, Your Honor.
Okay, so bottom of page 14, under sympathy, I think somebody had said, Mr. Greenwald maybe it said to remove remote resident of the state.
Well, I said that.
Mr. Brown, remove remote. I think if you just put local residents, it doesn't make sense. So I think you either leave it all in or take it all out. And I think just
Leave it all
leaving
in.
it.
No objection.
I don't think I had anything else.
Everything else appears correct to the state, Your Honor.
Yes, sir.
I'll kill some more trees and get some clean copies.
Judge, can we just go on the record one last time after further conferring with my client, Ms. Owens, it is again your decision, but you do not want to testify, so you understand the evidence is closed in the case.
So I just want to make sure, because that was a double sentence. You understand it's your right to testify.
Yes, I'm sorry.
And you have chosen not to testify.
Yes, ma'am.
And you understand the evidence in this case is now closed.
Yes, ma'am.
Or it will be when we have the jury come back in tonight.
Yes, ma'am.
All right, y'all enjoy lunch.
Thank you, Judge.
What time did I tell them?
12:30.
Prove this case against you, and it is a burden I welcome. And I'll have two opportunities to speak with you. I'll have an opportunity now, Mr. Greenwell will have an opportunity, and then I'll come back. Because again, the burden is mine alone to prove this case to you. And before Mr. Greenwell comes up, there's some things that I'd like to talk to you about. A little roadmap of the things to consider as you deliberate, as you process the information and the evidence that you have received, put it together with the law. But as you do, please remember, sometimes the truth is right before your eyes. Sometimes it's just not that hard. And this case is one such case. This case involves two people. They're both charged in this indictment, and Brittany Hall, she'll have her day. She'll have her jury, and we'll be ready. But today is this defendant's day, and she is charged as a party to a crime. The judge will tell you that this concept of a party to a crime is incredibly important within our legal system because it holds people accountable for their part in any crime. Each of you have indicated that you agree that it can take more than one person to commit a crime. That people can be held accountable for the roles that they play in a crime. That is what's called a party to a crime. You can either directly commit the crime, as you saw this defendant do in numerous videos that you have seen throughout this week, or you can intentionally help in the commission of that crime. And when I come back and we have an opportunity to look at that again, and you can hear the two voices that are talking in some of those videos and understand the context in which both of these people were living together, caring for these children, then you will see they acted together. And the reason that this concept is so important It's because, think about it this way. I like to help juries understand this concept in a very simplistic way. Think about a bomb maker. Think about someone who provides a weapon. You have someone who gives an explosive device. You have someone who gives wires for that device. You have a third person who puts it all together, and a fourth person who carries it into the middle of a crowded street and detonates that bomb. Well, guess what? Every single person responsible for the completion of that crime is a party to a crime, and either guilty because they did it, or because in some way they helped in the commission of that crime. This defendant helped beat the living life out of Amari. She is a party to a crime in every single one of that indictment because she had her hands all over that girl. Just like someone who provides a weapon. Here's two of the exact same guns. Please go over there and shoot up that school. You go over there and you start shooting the school, someone dies, and they say, well, I don't know which gun it was, so you can't actually, it's not me, it's got to be the other guy. No, party to a crime holds people accountable for the roles that they play in each of the crimes. And she is responsible for the role that she played. Keep in mind the method that each defendant used for abusing these children. The slapping on the back of the head, the stomping, the blindfolding, the laying on the ground. They did this together. Their method was together. So it doesn't matter who delivered the fatal blow. Because, ladies and gentlemen, there was not one fatal blow. Every single blow was fatal to Amari. Every single one. You saw that. You heard Dr. Down say that. So remember, because of the battered child syndrome that he explained, that we'll talk about again a little later, every single blow mattered. It doesn't matter. Just like it doesn't matter who pulled the trigger, it doesn't matter who delivered the fatal blow. It could be Brittany, it could be Celeste. It makes no difference. They are both guilty. And today is her day. Because if they both hadn't done it together, if she hadn't done her part, Amari wouldn't have been beaten to death. Doesn't matter who the main caregiver is. Doesn't matter who the biological mother is. None of that matters. This defendant, in her interview with Detective Sorensen, said, we're both the parents. I'm dad. That's what they call me. We never leave the kids alone. We're homebodies. We're always home. Together, they cared for these children. It doesn't matter who delivered any final blow, because every blow is a fatal final blow. That's what you saw over and 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 over again on Amari's little broken body. Every single blow mattered. And we know that they both lived together. They both cared for them together. That there is no doubt in this case that this defendant, who we've seen on video slap Amari so hard, was part of killing Amari. And one of the things that I'd like you to remember is what we have to prove. We have to prove all of these charges, all the elements of these charges, to you beyond a reasonable doubt. What does that mean? Everybody's heard that on TV. Everybody's heard that in the news, on the radio. It doesn't mean beyond all doubt. It does not mean beyond mathematical certainty, because remember, sometimes the truth is right before your eyes. Sometimes it's not that clouded. Reasonable doubt is that the judge will instruct you, the doubt of a fair-minded juror, honestly seeking the truth about what happened to Amari. This defendant is equally responsible for the role that she played in the death of Amari. Your job is not to look for doubt. Your job is to use your common sense, because sometimes the truth is right before your eyes. You will have evidence to consider. I'm giving you just a roadmap, the ingredients that you will need to complete your verdict at the end. You have heard testimony from numerous witnesses, law enforcement, medical. Is that here? This is right. Numerous witnesses who came in and verbally told you about the things that happened, about the things that they saw. You've seen multiple exhibits in the form of photographs. You've seen videos. You've heard about stipulations that we have agreed to. That's the evidence. And evidence can come in two different forms. It can come in physical evidence, like what you have essentially seen on video, the beatings that occurred. You can see the photographs of the physical state of little Amari. But there's also something called circumstantial evidence. We've seen her on video directly slap Amari. We've seen her directly beat those children. The law allows you to use by Mantner also participated in the beatings that went on for an extensive period of time to Amari. You don't have to see it to know what happened. It's just like you wake up in the morning and you thought you heard some rain all night long, and you're like, oh, I wonder if it rained. And you go outside and the sky is clear and blue, but you look on the ground and there's water and the grass is wet and there's water on your car. Well, it's pretty darn reasonable that it rained last night, even though you didn't see it. That's circumstantial evidence, and they both hold equal weight. Testimony is equally weighed as circumstantial evidence. And then you're going to look at the credibility of the witnesses who came in. You know, who has something to gain, who has something to lose. Going to see little Zaire. What did she have to gain coming in here? I want to talk about that. I want to explain the most important charges, because I think as we go through this indictment, that you will have with you when you go back, there's a lot of charges on here. Because she did a lot of things to these children. So there's a lot of charges. But the most serious of which start at the top with malice murder. Malice murder will be defined when a person commits the offense of malice murder when they unlawfully and with malice aforethought cause the death of another human being. Now I know it's a lot of legal words and things that may not really be used in our everyday language, but it's really very simplistic when you think about it. Malice murder is when there is malice or a malicious act that's occurred. Malice is defined where all the circumstances of the killing show what's called an abandoned and malignant heart. Okay, this is again a lot of legal words to say that you have essentially the circumstances in which you kill this child. Those circumstances are hateful and wicked and savage and spiteful. They are so malicious in nature. Like Amari's little body will show you, and showed you through the photographs, and showed you through the autopsy, her broken little body that was so beat. That is malicious in nature, done together. There's no premeditation that is required. This defendant didn't have to sit there and plan Amari's murder. She didn't have to do that, because malice, that malicious intent, can be formed in just a moment, and in an instant, even a fatal wound can be inflicted. Again, what this means is, it doesn't have to be one fatal wound. We know that. That's what Dr. Downs has testified. But the malicious nature in which those wounds were actually perpetrated and in which the death occurred, that is malicious. That's malice murder, and that resulted in her death. Causing multiple blunt force injuries to her little body means that she acted in malice. That's malice murder. Again, I just wanted to give you a roadmap, and we can talk about how all the evidence fits in. And the other charge that you will see here, it's a little different, but it's still murder. And please remember that you can find this defendant guilty of every single one of these charges, all the different murders, because there were so many ways in which Amari was killed. You can find her guilty of every single one of these murder charges. Felony murder is when someone is involved in the commission of a felony and you cause the death of another person. You don't need malice. But in this case, there's definitely malice. And there's definitely evidence that this defendant was engaged in 3 different felonies. Cruelty to children in the first degree, when she's beating Amari, when she's slapping Amari, it's an indication of all the other things that were happening in that hellhole of an apartment, studio, hometown studios, Congress Hotel. That was living hell based on the body of Amari. And we'll talk about each of these charges. She is charged in 3 different counts of felony murder for committing 3 different felonies. Cruelty to children in the first degree, causing physical and excessive mental pain to Amari. Again, we'll talk about that when I come back. I want to give you the roadmap of what you're looking at. 3 different felonies that she participated in, committed directly, or helped commit. Cruelty to children in the first degree, aggravated assault, aggravated battery. Each one of those is the felony that resulted in the death of Amari. That's felony murder. 3 different felonies, 3 different felony murder charges, and the malice murder charge because it was so malicious and vicious the way that child was beaten. It took 2 people to kill Amari. Like I said to you many days ago, it took 2 people to kill her, 2 people to cover up her murder, 1 person who I think the evidence is clearly